Good morning, dear friends, ladies and gentlemen. Welcome to our panel Guide to IP Creation, Exchange and Ownership in University and Industry. We have three distinguished speakers. The first one is Professor Goddar, and partner of Boehmert. And our second speaker is Ms. Vitra Dominic. And our final speaker is Dr. Lawrence Kaiser. Before we start our presentation, may I briefly introduce Professor Goddar. Although everybody knows Professor Goddar, if you are in the IP industry, he's a legendary speaker, experts, mentors for many people, for many generations, I believe. Professor Goddar is a German patent attorney, European patent and trademark attorney. He's a partner of Boehmert. He teaches intellectual property law at the honorary professor in University of Bremen, and also he teaches in Munich Intellectual Property Law Center. Currently, he also joined Brussels Law School Hamburg, as well as a lecturer in many leading universities in the world, not only in Asia and US. He's the former president of LES International and LES Germany. He has been received many awards. Here I'm just mentioning the gold medal of LSI and also the IP Hall of Fame. And since 2005, he's the chair of Standing Working Group of Industry University Cooperation at German Federal Ministry of Economy and Climate. Our second speaker, Ms. Vitra Dominic. She's intellectual property manager of SCG Chemical Public, a subsidiary of the Science Signal Group. She has been actively in the field of IP strategy, IP portfolio management, IP licensing, and commercialization of IP arts. She's the founder of LES Thailand and as co-chair of the LS Asia Pacific Committee. She's still active in IP licensing community by serving as the vice chair of Chemical Environment, Energy and Material Committee of LS International, and also a committee member of LS Thailand. Because also lecturer in IP management, licensing, innovations at several university, public and private sector in Thailand. And our final honorable speaker is Dr. Lawrence Kaiser. And he's the senior legal counsel at GE Aviation since 2019. Before, he has been the division director for R&D contract and IPR Fraunhofer in Germany, responsible for the department R&D contract, patent and licensing, public sponsoring, and corporate legal government rendering centralized service for all 400 institutes. His professional activity engaged in development of model for research cooperation and contractual solution, which include also the transfer of knowledge through spin-off of research facilities and universities. And Dr. Kaiser is also performing advanced training course for German and international expert group for R&D cooperation and IP management. He's currently also the Director General for QI MIP, organized by the German Institution of Inventorship. Today's topic is related to the university and industry cooperation. Allow me to show you the real case we have done for Hong Kong University. Hong Kong University is one of the leading universities. I have done many similar projects with universities in the United States, US, Japan, but I believe it's the best because as you can review from the patent profile, their patent quality, their patent values, and their patent distributions are pretty well organized. So we help them to categorize their patent list based on their patent quality, patent value, and also the high value patent on A61K and also C class. And the patents in EU, US, and WIPF is all the list. And I personally done that one by one to analyze patents for their quality and go into their claim, independent claim, and every detail one by one for a couple hundred patents.
Thank you.
And help them to find out the potential infringer, cooperation partners, industry partners and possible merger acquisition or trading opportunities. The tool we apply is from our sponsor friends, Inquatic. They provide pattern cloud, so we use that pattern cloud to analyze all the pattern qualities and values. IPV provide Zeus analytics for us to scoring their art and technology comparison with all hackers and patterns all over the world. So this is just an example. For example, this A-class pattern, their arts and technology score is 65 for the whole pattern. We also go into the detail for individual claim 1. Based on the claim 1, we found out the similarity arts all over the world, the top 80s, and found out the possible industry cooperators, their patterns and comparison percentage as well. This is just proof I have done we actually, university have done the one by one, go into the detail to find out the possible monetization and cooperation and commercialization for the patterns. So the tool, currently those two are very convenient. They, with AI and big data analytics, they help us to do the quality analyze pattern profile. They could even determine the essentiality. They could help you just in few clicks quickly find out the file wrappers, IPR proceedings, CBN proceedings, and PGR proceedings based on the reasons where they were rejected or one process. But they can give you the history of the prosecution and also those re-examination process. And they could go further into the second degree reference. The similar project we also serve the companies in Taiwan and China, also in Japan and Korea. So actually, the current tool, they help us with all those AI big data tools. It's very difficult for human being to do all this research by hands because leading university, they may have couple thousand patents. For the international corporation, they may have hundreds of thousands of patents. So how to manage their patent, find a suitable partnership, the tools, they help a lot. And they could even go into the detail to compare claim one by one. They can give you a claim chart. So it's much easier for the work we have to done for the due diligence, litigation, and support this monetization. But of course, university is focused on the research. For the industry, they have different perspective. So, in 1980s, fortunately, U.S. launched the Vital Acts. They give a lot of freedom and guidance, so they actually stimulate the economy of IP. There are over 5,000 companies have been spun off from universities. Over 40,000 licensing arrangements have been done, and they have created more than 40 billion revenues in the past. So today we're very honored to have our prestigious speaker to share their experience. Academic definitely need to work with industry, but there are a lot of dilemmas for the different perspective. So now may I pass the floor to Professor Goddar to share his experience and his suggestions in German. Professor Goddar, before you start.
Yeah, good morning, ladies and gentlemen, dear colleagues, dear friends. I have the pleasure to open this session. It should be more a dialogue, more a discussion, I think, than just presentations, at least as far as I'm concerned. Maybe out of what I'm doing, the most maybe important function I have is I am since 2005 actually at the German Federal Ministry for Economy. It is at the moment for economy and climate, will change again, it will become something else, but it is the German Federal Ministry for Economy. They have, upon initiative at that time of Angela Merkel still, with an advisor from Siemens, Herr von Pierer. He just had, in disgrace, I think, somehow been forced to leave the company more or less, but he was an intimate advisor to Mrs. Merkel in scientific research things, etc. They had an idea at that time to found an expert group or a committee, standing committee at the Federal Ministry for industry-university collaboration. What was the purpose? To start with, maybe I should mention first, they contacted me whether I would like to chair this, because somehow industry, big industry in Germany, and also, I'll give you a few names later, and also universities, chancellors, they trusted me that I would play a neutral role in that function. What was the intention? We had since 2002 in Germany a new law concerning inventions made by employees. That got, with effect of 6th of February actually of 2002, rid of the absolute professor's privilege which we have. That means until then, German Article 42 of Employees Invention Law, it is a special act in Germany since 1942. It came into force, one of the few laws which practically have survived from that time, which was not possibly the brightest time in German politics. The end of Second World War, more or less unchanged. And Article 42 provided for simply the fact that inventions made by professors, lecturers, and in German, wissenschaftliche Assistenten, you would now call them assistant professors, they are private inventions. That means there's no duty of such an employee of a university to even disclose the invention to the university, not to speak of even giving the right to use or to patent or whatever to the university. As a result, is a very interesting one, which objectively can be followed, I think, by the interested audience. Look at German patent applications and patents with filing dates up to, I would say, mid of 2003. You will not find a single even, or very few at least, only patents which are in the name of a German university. It was very interesting to see in the literature in the United States after Bayh-Dole came into force, and I could follow this closely in my function in LES International, that they said, wow, now we commercialize really inventions. Stanford was good in this, Reiners and whatever. We are now really commercializing inventions which come out of academic research. And I fully understood this. And there was also sometimes in discussions in international committees of LAS International and whatsoever, there was this discussion why, for example, one of the leading countries in Europe, like Germany, why they are so stupid that they don't do this. They have no university patents. You can see this, no university industry collaboration, nothing. It was not quite true, because these university-based inventions made by professors, etc., which I described, were never notified even to university. They were given directly by consultancy agreement, whatever you call it, to industry, funding that, and the deal was very easy. Industry got the invention and patented it in its own name. Professor got money. Not necessarily for his own pocket, I would like to say, but for scholarships, for electron microscopes, whatever it is. But university was sitting in the corner, professor was sitting here, industry you are, and here's a deal for inventions took place. University had nothing essentially to do with it. That is an absolute professor's privilege. Only very few countries have this still. It was interesting, on the 6th of February, our Italian friends, we wish to look into that, Mr. Berlusconi in Italy, for what reason soever, introduced an absolute professor's privilege, probably to do the same what our Austrian leader in Germany in 1942 intended to domesticize academia, to do them a favor so that they would be a little bit friendlier to the government than otherwise they would have been. This is a little bit sarcastic, but I am not an Italian politician, but it surprised me that on the same day Mr. Berlusconi formed further, I think in a year, half a year or so, new president, the state president of Italy. So he certainly has people he knows in academia. Anyway, so then the law changed. We got new Article 42, which people said now professor's privilege in Germany is gone. Not quite. Because it says, first of all, that all these people, all university inventors, let's in future now from now on call them professors, it's also others, that they are employees who have, they are employees anyway, but that they have to notify the invention, to bring the invention into the sphere of university, and university can then acquire these inventions. Like in industry, industry acquires it according to law concerning inventions made by employees from the inventor, the employee inventor in industry. So same thing, professor, a little bit different in so far. University gets the invention, university patents the invention, and out of the gross income of the university, out of the commercial evaluation of that invention, which in Germany means either licensing out or transfer of ownership. We have absolutely no provision in Germany, and the legislator has absolutely no intention to change this, that a university simply sells the invention to industry, which funds the respective invention. There's no problem with that, but what I'm talking about here is at this moment that I want to say that the professor or the inventor gets 30% of the gross income. So the university cannot deduct patenting cost, marketing cost, whatever they wish, nothing. It is just the price they get. And meanwhile, our, let's say, inventor-friendly German courts have even said, case law developed over the last 20 years in the meantime, that even if the industry pays for a patent application, for searches whatsoever, this is all as if they would give additional money to the university. So it is much more income, which is the basis for calculating the 30%. Very high percentage, much higher than you would find in private industry, much higher. There was also the provision therein, and this is what I mentioned now, and a little bit historical, but I think you need to know this in order to understand today's situation. There's also the provision that it applies this new law not only to future inventions made by university inventors, but also into existing agreements. That means all agreements, consultancy agreements of the kind I have described, which were concluded, let's say 1985 or 1992 or whatever, they all came under the German law, so that easily the following situation, which was a real one, could be created. There was a cardiologist in 1995. He had the chance either to go to Minneapolis, to a very famous heart pacemaker, well-known one, I don't wish to mention a name, into industry, or he could go to Berkeley as a professor with a certain income, which was a very high income, but not so high that it would reach what a German university offered, plus what he would get for his inventions. Because with that company in Minneapolis, if I remember correctly, he had an agreement which said you get, let's say, $300,000 US per year, and you give us for your lifetime all inventions you make. It was absolutely legitimate under the old law. So he accepted a modest offer of 70,000 D-Mark, or which were nowadays maybe even euro, and said, okay, I go to Göttingen and have my private consultancy agreement that gives me much more money than I would get in Berkeley or wheresoever. That was it. And then all of a sudden comes the German law change and says, this agreement can only be fulfilled until the 6th of February 2003 for 1 year more. From then on, unfortunately, no, you cannot get out of this consultancy agreement anything anymore in future, because your future inventions are now all under this new law. Of course, he went to court, Landgericht Braunschweig at that time, and Landgericht Braunschweig said, we don't think that this is constitutional, because this is expropriation. This is taking away property which he trusted on that old law, and it was a huge income he had in future, and he changed his life. He lived in Göttingen for that. So Landgericht Braunschweig put it to the German Constitutional Court, which is the highest legislator in Germany. Germany is not ruled by the parliament, it is ruled by the Constitutional Court at the end of the day. All controversial laws somewhere end there, and then the law is made. This is the only court where the decisions have binding effect for Germany. Not like normal courts, even the Federal Supreme Court, whatever they say, the next district court can go and say, oh, you are maybe nice, there was this circumstances of the individual case. We think differently. I mean, they don't do this too often, but legally spoken, they could do this. We don't look at references, not. So, Constitutional Court, the reason why he went there says this is illegitimate, that the existing agreements, the old ones, are now also under the new law. And the Constitutional Court said it is legitimate because there is such a high overall reward compensation for the loss of the professor's privilege by giving the 30% of the gross income of universities in future, that this is for the whole professorship for all university inventors, no more a illegitimate expropriation without compensation, but there is in the law a fair compensation for all this. This was the reason why it was considered as legitimate that we got the new law. A different solution would have been, and I had expected this, many people, scholars, lawyers, had expected this, judges, that it would be different. They would say, oh no, it's only for new contracts, but the old ones can still be fulfilled until the expiration thereof. They did not, so the change of law was legitimate. What did the government do now? Now, by the way, there is one thing, I said, partial loss of professor's privilege. They have now to give this to university, but if they wish not to publish their invention, it's an individual right. It follows out of Article 5 of our Constitution, freedom of research and teaching. Ample case law on this. They can decide themselves, do they wish to publish? Just imagine some professor has developed an invention, bacteriological weapon, which would be dangerous for humanity, and he would not wish to get it into the public. Then he has not to tell university. Very nice. So what does that mean? That means that university cannot make an agreement with industry, what industry wishes, namely to say, all inventions out of this project we are 100% paying for, that they develop a certain thing at a certain university, all inventions coming out are transferred to industry. Industry pays, industry wishes to sit in the driver's seat, and that was what industry wished in Germany. Even with the sweat, and if that is not fulfilled, we go to Britain or wherever, we don't wish to do research anymore in Germany. It was really serious, it was that serious. And what happened then was simply that in the universities could only tell industry, we give you all inventions that come into our hands. But the decisive person to decide what comes into the hand of university and thereby to industry was the professor, the inventor. Industry didn't like this at all. So the solution was obviously, that was openly discussed in various model agreements, that the professor made a contract with industry which said, I promise you not to make use of this negative right of publication. In other words, I give all my inventions to university. Fine, and thereby to industry. Normally such consultancy agreements, which are nice, of course, come not cost-free. That means there were now then private arrangements between professors and industry, where professors said, I don't use the negative right not to publish, in other words, but I do all inventions to the university, and thereby the world was involved. But you see already this is a complicated trilateral agreement. It is an agreement between university and industry to give all things university gets hold of to industry, and another agreement between professor and industry to give them what he has not to give to university. There cannot be a contract, employment contract for the professor, where he would renounce his right not to publish, illegitimate in Germany. Whatever diminishes the rights of an employee inventor compared with the law in Germany that applies to both private industry and also university inventions are null and void. You can write into an employment contract what you like. If it diminishes the right of the employee inventor, null and void. So I love always these nice contracts between, for example, clients of mine with a German branch where they have this nice contract, all innovations made by this employee go with automatic effect into the ownership or have to be assigned to the employer at the price of $1 or euro. So I tell inventors always, sign it. Beautiful. It's all null and void. Have a happy and trustful life with your employer, and when you retire, you come back to me. Because then there has something happened which is obviously unjustified. And in that case, the ownership of all these inventions were not legitimately given to the employer. You can claim them all back, and I had many procedures, not many, but so 4 to 5 procedures in that in Germany, where people came, for example, fathers of classmates of my daughter, and said, I have made so many inventions and never got a penny. It was a German subsidiary of a US company based in St. Louis having to do with foods, but anyway. He got a nice amount of money, has now a nice house at Tegernsee, which is one of the beautiful areas around Munich where you wish to live in your pension time. This is all possible. Now, what did the government do? What did Merkel do? What happened in 2005? They said, okay, this legal situation is complicated. Practically now, small universities, big universities, small and medium-sized enterprises which give 80% of the GDP of overall Germany, they all have to go to expensive law firms, maybe like mine, I don't know, and have to be consulted, individual agreements. We don't wish this. We wish to create a set of templates or model agreements which are unanimously supported by universities or the community of universities and the community of industry in Germany. And for that we put into place a standing committee or working group, and we have somebody like me, it was me, chairing that, and we will now create a set of model agreements which have found the nodding already of the industry associations, the academic associations, that this is a fair deal between these three parties we are talking about, the professors, the universities and industry. And they were from then on interesting to see until today, because they are yearly, annually updated. They're also on the WIPF website, of course. You can get through our moderator, she will ask me. There is a website available of the Ministry of Economy in Germany, but also of WIPF. I think it's the only country in the world where they have model agreements on file in German and English, and a handbook how to use these model agreements. And then we don't need to have small universities, small companies going to expensive law firms anymore. This was a little bit sarcastic, but this was really the reason for it. And this set of agreements is widely used, particularly by the smaller entities in Germany, the big ones. If you go to Siemens, if you go to Bosch, their relation to Karlsruhe Institute for Technology, if you go to Siemens University of Erlangen, if you go to BASF with other universities, to Mainz University, close and intimate relation with Boehringer Ingelheim, BioNTech, one of these companies there around, they have their own sets of agreements. They don't need the model agreements. This is a long, many decades lasting relation between certain universities and certain industry, and of course also research institutions like Fraunhofer, where Lorenz Kaiser has played such a leading role in the past before he went to his present employer. They don't need this. There is a set available, all taking care of this strange legal situation. But what do the normal people do? And since then we added these university industry collaboration agreements, and you can find them at the places which I told you. They are not only useful for Germany, they are also useful everywhere, I would say, in other countries. You don't have to follow then the strict rules of the German employee invention law, of course, but they are quite useful to regulate in all cases where industry uses universities as outsourced laboratories, development centers or whatsoever, and they are the basis of many negotiations and also conclusions of agreements. I saw this recently in connection with the Westfälische Wilhelms University in Münster, who have a big contract now on battery technology with a Korean company, which I know pretty well. And That was a useful enterprise, and it's being done. And so industry-university collaboration in Germany follows largely, as far as not big institutions like Max Planck Society, like Fraunhofer are concerned. Helmholtz is following, but not the first to mention, follows essentially this collection of templates with a handbook, how to regulate all this. And I think this is all about the German situation, I should tell you here. I think we have regulated it. There's no real dispute, always a question here and there, who should bear this cost, who should bear these costs, but essentially the situation is settled and well established since 2002, not before. And it came only this contract, the first version came 2007. We started 2005 to negotiate, and it was really the breakthrough came, and this is public, through company of Bosch. You know them, the largest and biggest German car manufacturer. You will not find them in the Volkswagen, Porsche, Daimler, or whatever. But German cars essentially consist of Bosch parts, and outside is a nice body and a trademark of somebody else. So it is a lot of common technology of German car industry. And Bosch at that time made the proposal. Bertram Huber at that time, who you already know very well, he was one of my successors as president of LAS Germany. He made this proposal that two demands of universities and industry could be fulfilled. Industry insisted strictly on, we wish to be in the driver's seat. If we pay, we own the invention, please. Otherwise, we go to Britain or into the Sahara, I don't know where, but no research anymore in Germany. A big threat. Universities said, you are joking. We need in future to be owners of inventions, because the ranking of German universities, which decides on the public money you get from subsidies from federal government, from certain federal states governments, etc., depends largely on the number of primary patent applications you file every year. And then Bertram Huber at that time, he suggested, and it became then part of these agreements up to today, he said, why not following provision? The first patent application is made in the name of industry and university as joint owners. The first filing. Then the university has fulfilled its demand to be a filer, a primary patent application, so not alone, but this does, interesting enough, not play a role for the ranking under German Federal Ministry for Higher Education and Research. It doesn't matter. Industry is in the driver's seat. They pay, they dictate, they file either in their own name or together with university this first application, and all following applications, foreign ones. Let's say you have a German patent application and file now a European one, a so-called. There is no real European patent application up to now, we all know this. But anyway, there is this bundle patent application under EPC, and this you file, that is already a secondary application, or a US application, a Chinese one, an Indian, a Taiwan, whatsoever. This is all fine. They can be in the name of industry alone. It's at the discretion of industry. But the first filing, which counts for the ranking, is in the name of both parties. So this is one of the elements which survives the decades up to now of these arrangements according to the so-called, we call it BMWI. You will always read BMWI contract. It has nothing to do with BMW. It is Bundesministerium für Wirtschaft. It is Federal Ministry for Economy. So these are the BMWI agreements which you will find under this name in WIPF. And you are invited to have a look there. If you have further questions, ask our dear moderator, our dear friend Professor Mei-Hsin Wang, and otherwise you can also ask me directly or any of the panelists here. I know, for example, Vikram, one of our speakers here of a company in Thailand, not unknown to me, neither Vikram nor the company, makes use of similar provisions like these agreements we are talking about here in many instances, and ask them, and I'm happy to help also. Thank you very much.